state and this honorable court.
Good morning. Our next case is Canteen et al. Versus the Charlotte Metro Credit Union. We'll hear from the appellant.
Mr. Chief Justice, and may it please the court, I'm Troy Shelton, and I represent Ms. Phillips in this appeal. I'm here today along with my co-counsel, Bess Miller, and Nathan Wilson. I'd like to reserve 8 minutes for rebuttal. This case is about whether one person can unilaterally impose arbitration on another. The answer is no. Arbitration requires agreement. There are many ways that businesses can have arbitration agreements with their customers, but this case presents a good example of what a business cannot do. The credit union carries the burden of proving that a valid arbitration agreement was formed. To carry its burden, it has just 2 options. First, it can try relying on the unilateral modification clause, but that clause is plagued by problems. Second, the credit union can drop reliance on the unilateral modification clause and try proving acceptance through silence. But that argument is novel, unprecedented, and unsupported by the law. I'll turn first to the problems with the unilateral modification clause. The primary problem with this clause is illusoriness. If an agreement purports to let one party later change the terms, that's an illusory promise, and an illusory promise does not make an enforceable contract. And the cardinal sin with this unilateral modification clause is that it lets the credit union unilaterally modify the contract retroactively. That means that even today, the credit union isn't bound to arbitrate anything with Ms. Phillips. It can erase the arbitration clause tomorrow if that's what it wants. This issue has come up repeatedly in the federal appellate courts. In those cases, a defendant will move to compel arbitration when the original contract actually has an arbitration clause in it, undisputedly. But the contract also has a unilateral modification clause. And the existence of that clause in the contract, these federal circuits all hold, renders the arbitration clause itself illusory because the business isn't bound to arbitrate at all. Now, the credit union hasn't disagreed with anything that I just said. It doesn't dispute our argument on illusoriness. And if nothing else, I think this court could write an opinion simply assuming that the unilateral modification clause is unenforceable due to illusoriness. And with that clause off the table, the credit union is stuck having to prove acceptance through silence. Alternatively, though, if this court doesn't find the unilateral modification clause to be illusory, it would still violate the implied covenant of good faith and fair dealing. As the Court of Appeals held in the Sears case, and other courts and scholars have noted across the country, the implied covenant prohibits one party from exercising its discretion to recapture a foregone opportunity. Now, the credit union doesn't dispute that standard, the recapturing of a foregone opportunity, and the credit union doesn't dispute that it could have bargained for arbitration back in 2014 if that's what it wanted, nor does it dispute that it was seeking, in fact, to recapture a foregone opportunity. And that's enough to resolve this argument too. In fact, even the credit union's restatement of consumer contracts deems retroactive modifications to be a violation of the implied covenant. So this is an additional reason that the credit union can't rely on the unilateral modification clause. For our last
Counselor, man, I'd like to ask a question about the consumer restatement that you are speaking to, with which you're speaking. How should we view that? It's certainly not precedential. I understand your friend on the other side pointed out that there have been several versions of that, and certainly it's not necessarily a restatement of any law at this point. What is your position with respect to how we should view the consumer restatement that you're talking about?
I think this court should discard the restatement of consumer contracts. I don't think it's a restatement of the law. It doesn't appear to be the common law in any jurisdiction. It's certainly not consistent with the many common law cases cited in our brief. As we noted in our reply, it's criticized by both pro-consumer advocates and pro-business advocates. And I get, sometimes you have something that gets criticized from both sides, and we think maybe it's a nice compromise. I don't really think that the restatement of consumer contracts is that kind of nice compromise. I think it is, in fact, just a poor restatement. But as we noted in our reply, we prevail under the restatement of consumer contracts. So if this court wants to adopt it, and I think we'd still win. But just as a matter of this state's jurisprudence, I think it would be inviting confusion to adopt that restatement.
And what is your position about, I believe it's the restatement second? What is your position with respect to that restatement?
So the primary provision that we've discussed in our brief is Section 69, which is essentially acceptance through silence. And when those exceptional circumstances exist, we believe this court should adopt Section 69 of the second restatement. We think that that's consistent with the law in the state, and we think that that's consistent with the law really across the country. So our last argument on the unilateral modification clause is that the credit union couldn't use that clause to add an arbitration rider, because by the terms of the unilateral modification clause itself, there could only be changes and not additions. Now, the credit union says that it was changing the venue selection clause, but that is objectively false. If you hold up the old venue selection clause beside the new venue selection clause, you see that they are identical. Instead, what the arbitration rider is a new multi-page addendum tacked onto the end of the contract. The credit union can't identify any term in the original contract that the arbitration rider changed. Ultimately, it was the credit union that wrote the unilateral modification clause. If it wanted to allow additions, it could have written that, but it didn't, and now the clause should be interpreted against the drafter. With the unilateral modification clause off the table, the credit union is left having to prove that Phillips accepted through her silence. But this court and most other jurisdictions across the country have held that silence by the offeree doesn't result in acceptance, except in unusual circumstances. As I was discussing with Justice Behringer earlier, this court hasn't spelled out those circumstances, but I think a fair guidepost is Section 69 of the second restatement of contracts. We're fine to have that section, that standard applied here. In fact, a very helpful case to look at to see how it would apply here is the land case, which had not come out when we filed our opening brief, but had come out by the time we filed our reply. That's a decision from the Supreme Court of Indiana. And it was a lawsuit identical to this one. It was a customer suing a credit union, and they were arguing acceptance through silence. And the Indiana Supreme Court expressly adopted Section 69 and said that it wasn't met under the same circumstances here. Now, the credit union wants to say that Phillips couldn't take the benefit of the arbitration rider without also accepting its burdens. I don't disagree with that kind of inconsistency standard, and I think that that standard is consistent with Section 69. The problem here is that Phillips never engaged in any kind of inconsistent conduct, nor did the trial court find that she did. Instead, Phillips' conduct was entirely consistent with someone who never saw the arbitration rider in the first place, and as the trial court found as a fact, she in fact didn't ever see the arbitration rider. And the credit union can't say that by continuing to keep her account open, that was accepting some benefit from the arbitration rider, because because keeping her account open wasn't a term of the arbitration rider at all. And as the Indiana Supreme Court held in the land case, maintenance of the status quo is consistent with a rejection of the offer. Plus,
Counsel, can I ask a clarifying question? I think in the majority opinion, they may have been mistaken about the full text of the amendment being in the emails. I read the briefs and couldn't find in the record where there was the full text. It was the hyperlinks. Am I wrong about that?
The full text of the email in our case, Your Honor? It is the full text of the email is in the record. I think we actually had copied and pasted a picture of it.
I'm sorry, the amendment is in the email or hyperlinks are in the email?
Sorry, the amendments are not. So when you get an email, it doesn't say that you need to act now or do anything. It just says, changes of terms, here's some links.
That's what I thought, but then the majority opinion said here, not only did CMCU's email notice include the text of the new amendments, I didn't see that.
The actual text of the amendments is not in the email. I don't expect that my friend on the other side will dispute that. You'd have to click through to see it, and then you'd have to read that to know, oh, maybe I should opt out and take some action.
And this certainly goes to Ms. Phillips, what we think she knew, what she saw, what information was available to her for her assent.
That's right, Your Honor.
Counsel, you mentioned opting out, and you've got some arguments in your brief about constitutional rights. Can you sort of walk me through why in this contract those arguments are important?
So this is one of our alternative arguments. I think that it's most important to look at what rights are being waived here, because they're the ones relying on an extraordinary form of acceptance through silence. And so assent by silence, so to be clear, parties are free to waive their constitutional rights. In the criminal context, we see that all the time. When a criminal defendant enters a guilty plea, they're waiving their constitutional rights to go to trial. But we make sure that it's a knowing and voluntary waiver. But there's a presumption in the law against such waivers. And to overcome the presumption, the waiver of rights has to be knowing. And the credit union doesn't argue that it can satisfy that standard. And the findings of fact in the trial court's order would make it impossible, because it found that Ms. Phillips never knew. So if they wanted to get clear assent, they needed clear assent. They could have sent an email that said, would you agree to arbitration? Agree, disagree. The email could have been as simple as that, but that's not what the email said.
And this is a class action case?
This is class action, Your Honor.
Why wouldn't your opt-out argument apply to individuals you have included in the class?
I'm not following.
Voluntary waiver of rights. I mean, you said these are very important constitutional rights, but someone could, through silence, be included in a class. What am I missing in terms of consistency in your argument?
That's simply how the rules of civil procedure are written. The default is you have to opt out to not be included in a class action. I'm not here to defend, I believe that's simply a policy choice. I think that the legislature could make a policy choice that's different than the default rule for overcoming constitutional rights. They simply haven't done so.
So on the practical side, if the credit union wanted to under your view of the law, if the credit union wants an arbitration provision, it has to obtain consent, and if it doesn't, then what's it left with? Closing the account, terminating the relationship?
Yes, though this wasn't an at-will relationship. They were actually limited in how they could close the account. So I think there are a few options that the credit union has disposal. First, let's back up to 2014 and ask what could the credit union have done then. Probably could just put an arbitration clause in the original agreement like virtually everyone else was doing in 2014. What they also could have done to modify it was, like I mentioned with Justice Berger, could have sent an email, say agree, disagree. They could do what virtually all of us do every time when we log on to the internet. When she went to log on to her web banking services, say, we've changed the terms of services. Do you agree? Click agree, disagree. I think there were a lot of options that were at the credit union's disposal. And they didn't try to do really any of those. They're really in a position of their own doing because of that.
And correct me if I'm wrong, but with respect to the law favoring, or the law favors arbitration as a general matter, but you say that's irrelevant here because first you have to have an agreement to arbitrate, right?
That's correct, Your Honor. Courts across the country agree. At the formation stage, the presumption does not apply. One other thing, and this is sort of suggested in Section 69 of the restatement that the credit union could have done back in 2014 was could have changed the common law rules regarding how the agreement could have been modified. It could have said, instead of having this broad, open-ended, retroactive modification clause. It could have said, we will send you notices, and you will have 30 days to opt out from those. And if we don't hear back from you, it's going to be deemed an acceptance. Under the restatement, that would have been fine as well. But these are all the things that the credit union didn't do. And they're essentially asking the judiciary to try to help them out for something that they decided not to do at the time. So they're trying to go back and add an arbitration clause when that could have been done a decade ago.
And what's the significance of the language that the credit union did provide here, which, if I'm understanding the record correctly, your client could not have taken advantage of?
So the language in the letter said you can opt out. Whichever is sooner. I think 30 days from opening your account, or right after you open your account, or 30 days from now. But whichever was sooner was forever. That was a decade earlier. So she didn't actually have a right to opt out. Now, I don't think that the ability to opt out or not is relevant. Under common law principles, that is not how contracts are formed. If Mrs. Phillips sent an email to the credit union today, tomorrow, saying you agreed to put $1,000 in my account every day unless you opt out, we'd all laugh, right? I mean, that is not a contract, but that is identical to what happened here.
Well, it is different, isn't it, in an important respect. The agreement, the original agreement, has this provision that allows the credit union to make changes. The credit union, and so your client agreed to that, right? You now say it's illusory.
Yes, Your Honor.
Right, but your client agreed to that. The credit union didn't agree to a comparable provision saying that your client could change the agreement. So doesn't that render your hypothetical inapposite?
I don't believe it does, and here's why. In a scenario where we're talking about acceptance and mutual assent, we're in a world where we're not talking about the unilateral modification clause because we've already taken that clause off the table. And when we're talking about you send a letter and you have the right to opt out or not, that's when we're talking about acceptance through silence, which doesn't depend on the existence of any unilateral modification clause or not.
So for your hypothetical to apply, we have to agree with you in the first instance that the clause is invalid.
Yes, that's an argument for the acceptance through silence, yes. We have our argument about illusoriness. We believe the federal courts of appeals are unanimous on that point. We think that they're well-reasoned decisions. I haven't heard my friend on the other side say anything about illusoriness or any of those cases. I think that they apply faithfully. They apply just as easily under North Carolina's law of illusoriness. Well, if the court doesn't have any other questions at this time, I'll sit. Yes.
I actually do. Would you comment on the potential retroactivity application of this? And I'm going to ask your friend on the other side the same question.
Yes. So Mrs. Phillips' claims accrued between 2018 and 2020. That's when the overdraft fees that were not, in our view, not appropriately dinged against her, were dinged against her. The arbitration rider was added in 2021, and it reaches back in time to misconduct that had already occurred at a time when she had a right to go to court. And essentially, that is the retroactivity. That, if your question is, how is this retroactive? That is how it's retroactive. The rider was added at a time when the claims had already accrued.
And to follow up, is your position that that's inappropriate?
I think that's inappropriate always. Yes, Your Honor. Unless the court has any other questions, I'll save the remainder of my time for rebuttal. Thank you.
Thank you, counsel. And from the appellee.
Good morning, Mr. Chief Justice, and may it please the court. I'm Stephen Bader from Cranfield, Sumner, and Raleigh, here on behalf of the Charlotte Metro Credit Union, now known as Skyla. What Phillips is asking this court to do is say that credit union member agreements in North Carolina cannot be amended to include arbitration, even when the member agrees in the first instance that the agreement can be changed, and even when that change is sent to the member and she has an opportunity to opt out. That proposition is contrary to fundamental North Carolina contract law and the idea that contracts are interpreted according to their plain language to effectuate the intent of the agreement. It's contrary to the principle that agreements to arbitrate are treated the same as any other contract, and it's contrary to how other states and other jurisdictions faced with this issue have resolved the question. Now, this case is before this court on a dissent from the Court of Appeals. That dissent would reflect an outlier position. And if this court were to accept it, along with what Ms. Phillips is arguing here today, it could have significant effects on our economy and how credit unions in particular engage with their membership. And I think it's helpful to start here with what we do agree on, which is this original member agreement. The very first paragraph, Ms. Phillips agreed she's going to be bound by the terms of this agreement, its attachments and addenda, and any amendments. Going forward into paragraph 23, she agrees that the credit union can change the agreement with notice to her. And to paragraph 34, the governing law section states that any legal action regarding this agreement shall be brought in the county in which the credit union is located. So we look at the plain language of this contract. This is the credit union saying to members of the public, princes and paupers alike, if you want to bank here, here are the terms we're offering you. And Ms. Phillips agreed to that, including the idea that this agreement could be changed with notice to her. Then we get into the arbitration change itself.
So what's your response to the argument that by giving the credit union essentially unfettered discretion to modify terms, that the notice of amendments provision renders the agreement illusory?
Justice Allen, I don't think that reflects the facts of this case. I don't think that argument reflects the facts of this case or the law in general. This is not it doesn't give the credit union unfettered power to do whatever it wants. It says you take a look at this agreement and what you agreed to, and we can change it with notice to you. And that issue has come up time and time again, other courts that have been presented with the same fact. And really what they've looked at is, did the original agreement constitute dispute resolution in some form? And even if it did not, was the notice given, the change notice given to the member in the manner in which they requested it? And after they got it, did they continue to use the account or the service? Those tend to be the hallmark factors that are considered. And when all those facts are present, which are present here, those courts have said that's an effective change. When some or all of them are not, courts have been more reluctant to do that. And when we look here...
So just so I can understand your answer, you're saying that this agreement, the only limitations on how this agreement can be changed, and those limitations mean it is not an illusory agreement, are that the agreement had to contemplate some dispute resolution, and there's a procedural requirement that notice be given.
With respect to changes in dispute resolution, that is how other courts have looked at this issue. In the broader sense, as far as what the credit union's ability to change would be, I think that's different, and that would depend on what the proposed change is. But the proposed change before this court was this change in dispute resolution. And what the record shows is that Ms. Phillips was sent this proposed change by email 3 different times in the first quarter of 2021. She made the election to receive notices by email, so she got these in the manner that she requested. The email itself, in the subject line, reads, CMCU online statement and changes to membership and account are agreeable. So the first thing it's telling her when she gets the email is there's changes to her membership agreement. From there, the body of the email does list the hyperlinks to Justice Riggs' question about the Court of Appeals' apparent misstatement, and then the agreement itself is pulled up when somebody clicks on that, on the hyperlink. And what the agreement says is that certain account disputes are going to be subject to arbitration. It says that it does not apply to loan disputes, does not apply to cases brought in small claims court, and the agreement says that if a member wants to opt out, they can do so within 30 days.
But it did say within 30 days of opening the account, or receiving this notice, whichever is earlier. So that, if she read that and tried to understand what that meant, she would be out of time.
Couple ways to answer that question, Justice Riggs. First of all, that didn't happen in this case. I think that that argument perhaps would be more compelling if Ms. Phillips had provided some sworn testimony that she was unsure what to do, she understood she was out of time and couldn't take any action. But the record is that she doesn't recall receiving the email as well, although there's no dispute that it was sent her 3 different times. I guess the second comment I would raise very lightly is that that issue was brought up at the Court of Appeals. The majority rejected the idea that that would make the argument somehow ineffective. Justice Arrowood did not embrace that in his dissent. There was a petition for discretionary review on that particular issue, which this court ultimately did decline.
Can I ask you to respond to what I think I heard your colleague say, which is if you compared the choice of law and venue sections before and after, they're identical. There was an addition of this arbitration language. Do you dispute that? It just seems we're getting into very common sense language about modification versus addition.
Justice Riggs, I can't deny that that part of the agreement remained the same in both the initial and the amended agreement. But what I would say is that when you look at the arbitration change, it doesn't render that initial venue selection provision ineffective or not part of the agreement anymore. I mean, there are still claims like loan disputes or claims that would go to small claims court that would not be subject to arbitration. And so really the question is, can those two provisions be reconciled? And the answer is that they can. Because for individuals that have a claim that wouldn't be subject to arbitration, or if the credit union and that member decided not to go to arbitration, that would be the form that they'd agreed to.
But CMCU could have added in venue, and we can, we're contemplating this as a change in venue C, section whatever at the end. They didn't do that, and so they really did leave unmodified the parts of the agreement that I think as I understand it, they're now saying they were modifying.
I can't disagree with your comment that they could have done it different, but I would state that the fact that they didn't doesn't change the ultimate effect of the change itself. And, the Court of Appeals, and I cited the Internet Inc. versus Duro case, has gotten this issue before to try to reconcile both a forum selection clause and arbitration clause, and said that's the fashion in which you reconcile them. The arbitration clause would be favored, claims would go there. If the claim doesn't fall within arbitration, then you could look to the forum selection clause for where the dispute would be resolved. And really that issue also is fleshed out by this court in the R.N. Rouse decision, a case where Johnson County took the position that in a construction contract they were not subject to arbitration. That was the case that also had an arbitration agreement as well as a forum selection clause in the supplementary general provisions. And what this court said, certainly in particular on arbitration in general, and I think it's kind of fundamental to their argument, is that any doubt concerning the existence of any such agreement should also be resolved in favor of arbitration, which is, of course, the larger policy point here. So even if they could have done something different with how that governing law provision read, it doesn't change the larger points that there was an agreement to change in terms, this was a change in the terms, it can be reconciled with that original agreement. And I guess the last thing I'd point out on that is I think Ms. Phillips, at least at one point in her reply brief, even offered that comment that initially what she bargained for was a forum in Mecklenburg County, but that then changed when this arbitration change went into effect. The North Carolina case law that my colleague has cited and relied upon do not involve contracts like this. They don't involve what we've kind of referred to as almost standard form consumer contracts that all of us enter into for various things. They involve particular contracts that were negotiated between individuals. I know he's got a case that involved a timber contract. I think one is a marital dissolution. One of them, I believe, involved a real estate transaction. But in each of those cases, you had some party saying after the fact there was a modification, we negotiated something different, and that's where a lot of these principles about unilateral modification are inapplicable here, because to Justice Allen's earlier comment, what the credit union offered was that they would change terms. That was part of the agreement, and Ms. Phillips accepted that. And while this issue has not come up before our courts, it's not a novel issue. It's come up in different states, different circuits across this country. And again, by and large, how those courts are coming down is they're looking at three particular factors, not any one of which is dispositive. Number one, did the original agreement contemplate some form of dispute resolution? But even if it didn't, the second thing they're looking at is, was the notice, was the change sent in the manner that the member requested in a conspicuous fashion? And then did they assent to that change, not through silence, but through continuing to use and take advantage of the service that they'd contracted for? That's really what this case comes down to. And all of these cases—
And Counselor, it sounds, at least in your brief, there was citation to the consumer restatement, and some of the arguments you're making now, you relied or at least cited to that document. Could you please, and now it's in several later stages, and from what I understand, it's the final document's not even public yet. How should we use that document?
Strictly as a resource. It's a resource that has gathered where these cases, these various kind of cases that have come up and what courts have looked at. My colleague is right. There are law school professors who have criticized it for various reasons. One of the critiques I saw was that one of the hypotheticals about parking and a parking owner's liability didn't accurately reflect the law of bailments. It's really not what we're talking about here. I think the cases themselves that are cited within that resource say what they say. And the facts of those cases, when matched up here, would come out in favor of arbitration.
In looking at that resource, it does take a position about retroactivity. How should we look at that part and the fact that there is at least arguably a retroactive element in the case before us?
I think that issue depends on how you define the term retroactive. And one of the cases that I cited, Wainblad versus Comcast, which is a case from Massachusetts, cites another First Circuit opinion, National Federation of the Blind versus the Container Store, and they talk about retroactivity. And what they say is a retroactive change is one that would strip the right of arbitration from a party who has already invoked it. So it's not so much that there may have been a claim out there that a later amendment could cover. It's that somebody had made an attempt to try to arbitrate a claim, and at that point, the credit union, the institution, whoever it may be, took the position that they could change the agreement.
But why would retroactivity apply to only one side in that way? Why would that make sense? I mean, I understand under the facts of a particular case that might, but why should we define the term retroactivity to only apply for the credit union and not apply for the consumer?
Justice Earls, that's how the cases have viewed it, given the change provision that's included. When a credit union has that right to change terms, and it then changes the terms, and part of that change says that this is going to cover claims that have already accrued, and the member agrees to that through their action, it's covered. And this particular change says, and this is in the record at page 117, the agreement itself, that arbitration applies to any and all such claims or disputes, whether they arose in the past, may currently exist, or may arise in the future. And so it comes back to really a freedom of contract principle, which is that the member says, I agree that these terms can be changed with notice to me. She then gets the notice. She also gets a chance to decline them, and she does not. The other two comments about retroactivity that I think are important here is, number one, Ms. Phillips still has the right to pursue the wrong that she alleges against the credit union. It's just a matter of where she does it. So the credit union has not gone in and said, you cannot pursue any relief against us per this change that we've sent you. And I guess the second point that I would raise related to retroactivity is that in different senses, it's not really been briefed here, that issue can come up when the General Assembly makes changes to statutory causes of action or statute of limitations or things of that nature, and we talk about when rights are vested. This is a private agreement between the consumer and the credit union to which she agreed to these particular terms and then ultimately had a chance to decline them and did not. So to kind of get to the case, sort of the touchstone case, Batty versus Bank of America, and that's a California Court of Appeals decision from 1998. And the reason I reference that case is because that's the case that much of my colleagues' argument has been built on. And it's been built on going back to the trial court up to this date. And that was a case where the California Court of Appeals said, Bank of America, you cannot change your membership agreement to require arbitration. But there's two key aspects of that Batty decision that are missing here. The first is that there was no dispute resolution contemplated at all in the original agreement. And the second is that there was no ability to opt out. And those two factors touched on many of the arguments you're hearing today: illusory, good faith and fair dealing, those type of arguments. That's what caused the Court of Appeals in California to come down the way it did. Following Batty, you had several decisions that came out the same way under the same rationale. Decker versus Star Financial Group, that's an Indiana decision from 2023. Dispute resolution not contemplated in the original agreement. The facts of that case are also very strange because in that case, counsel had sent a letter to the credit union asking about some charges, and then 2 months after that, the credit union tried to send in a change with no dispute resolution in the original agreement and only gave the member 10 days to decline it. Not the facts that we have here. Sears versus Avery, which is the Court of Appeals decisions from this state applying Arizona law, in which, again, dispute resolution not even hinted at in the original agreement is the language from the opinion. The member there also had to pay down or close out the account, I believe, before they could attempt to opt out. Same facts are present in Maisel versus Best Buy, an unpublished Ohio Court of Appeals decision that's been cited, as well as Sevier versus BB&T, a Sixth Circuit opinion from 2012. I think in that Sevier decision, there was also no ability for the member to opt out or decline the change. We cited to the court, and I think to some extent it gets to what Justice Riggs was asking, at least a Southern District of New York decision, Philho versus Saffron National Bank, primarily because it was the only case I could find nationwide that looked at a similar form dispute resolution clause. And in particular, that clause said legal disputes must be submitted to the non-exclusive jurisdiction of any state or federal court sitting in the district in the office at which the account is maintained. It's not identical to our language, but it's the same functional idea that if you're going to bring a suit, you got to do it where the branch is located. And the court said that's a dispute resolution provision, and when you change it to and because it was in the original agreement, a change in the form of arbitration was contemplated. I think the two cases that I briefed, and I think that are most kind of bring these various moving parts together, is Macasero versus ENT Credit Union, which is a Colorado Court of Appeals decision from 2023, and Needleman versus Golden One Credit Union, which is a district court decision from the Northern District of California in 2020. Interestingly enough, they mirror the facts of this case very well. In both cases, you had a member that joined the credit union in 2014. In both cases, apparently, dispute resolution was not included in the original agreement. And in 2019, those credit unions changed their terms to require arbitration, or I guess would be in addition if it's not in the original dispute resolution, which would be different from what we have here. And in the Macasero case, almost identical to what happened here, the member said, I want email notices, and got an email about their monthly statement that included these hyperlinks. And that opinion actually was out of its way to say there was no mention in that email or the hyperlinks of arbitration at all. The member would have to go in and click through it. But that was how he wanted to receive his notices, and like Ms. Phillips here, he didn't do it. He also had a chance to opt out of arbitration, I believe it was 60 days, and didn't do it because he said he never saw it. And interestingly enough, the claim that he wanted to bring was related to a 2008 loan that he had paid off, and this change didn't occur, I believe, until 2019, with suit filed in 2020, so it would have the same retroactivity issue. And the Colorado Court of Appeals, just looking at fundamental contract principles that apply here, said what you have is a situation where an individual said, I agree that this membership agreement can be changed. This is how I want to be notified if that happens. Those notifications are sent, and what he does is he continues to bank and use the account, accepting the change as set forth in the notice. And the Court of Appeals said that notice is sufficient, and there is assent for that arbitration agreement to be enforceable. Functionally, Needleman is the exact same fact pattern. The only difference in there would be that the member agreed in the original agreement to get online and check their accounts from time to time, got an email that monthly statements were available. Had he checked his account at that point, he would have seen there was an arbitration change, didn't do it. And even the Federal District Court in California said that touches all the hallmarks of an appropriate amendment to the contract. It was sent to him the way that he wanted. He had an opportunity to opt out, and he did not. There's no shortage of other cases that I've cited that involve those. I guess I just draw this court's attention without further discussion to Wainblatt versus Comcast, another Massachusetts decision. I think I referenced that one earlier. Howard versus Feral Gas, which is a Federal District Court decision from Kansas. And then Valle, I think it's Valle, V-A-L-L-E, versus ATM, a decision from the Southern District of New York in 2015. I want to address a couple of the cases that Ms. Phillips has sort of cited, and I think, unless I hear something different, I think these are primarily the cases that they are relying upon, other than the baddie line of decisions, to try to get to the outcome that they want. The first case is Dasher versus RBC Bank, an 11th Circuit case from 2018. The facts of that case are just kind of make you shake your head. In that case, you had a bank that tried to compel arbitration. The motion was denied, and they were in litigation. And so then what they did is they said, well, let's change it and send it to the member now. And so they did that, and the member didn't respond, and then they tried to move to compel arbitration again. And the 11th Circuit had kind of the same reaction all of us are having, which is, well, wait a second. You're in litigation with this person. You didn't send it to their attorney. You tried to send it to them and then say, well, because they didn't opt out, that's acceptance. And all the 11th Circuit really said is that that's an equivocal communication at best from the member, the fact that they didn't respond. But really they were troubled by the way that the bank tried to go about it. That's not the situation that we have here. It's not even close. And the only other decision they cited is this Pruitt versus Wisconsin credit union case that came out late last year. I would point out, as far as that case goes, that really it relies much on the Batty, the Sears versus Avery, Sevier, those other decisions that I've already discussed, where you didn't have arbitration or you didn't have dispute resolution, in the original agreement, but also there was no opportunity to opt out. That case certainly comes out in their favor. I can't say that it doesn't. The Wisconsin Court of Appeals simply looked at the issue different. I would point something out, though, that I think is significant about the decision, and that's this. Part of how they came down was on this final argument that Judge Arrowood did not embrace in his dissent, which is the idea that there was some confusion about how the member could get out. And it's important what the court said about that, because they said, well, we acknowledge that in certain circumstances, failure to opt out of an arbitration provision can constitute acceptance. Under the circumstances in this case, the purported offer is not sufficiently clear to reasonably convey what was required of Pruitt to demonstrate his assent to or rejection of the modified terms. Well, that's not an issue in this case. I mean, what the Court of Appeals decided, and was before this case, is that she got sufficient notice, she knew what she had to do, or at least was told what she would have to do, and she didn't do anything. The last point I want to touch on is, and really it's just address a question that I believe Justice Allen asked about how the credit union would go about getting some kind of a verbal or a written consent from a member of the credit union. I think the answer is they can't. I think it's impossible. I think the click wrap argument would only work if this was exclusively an online platform. It's not. People at credit unions can still bank with paper. They can get things in the mail. So the best that could be said is the credit union could send them something in the mail, but they can't do anything if the person just ignores it. I mean, all they can do is say, here's your chance to opt out. We're giving you a reasonable period of time to do so. Please let us know. But if we don't hear from you and you continue to bank with us, you're going to have accepted that term. This isn't Netflix. They can't shut you down and say you can't watch another show until you click. You can't shut down somebody's bank account when they're buying groceries and say, no, you need to log on and answer some questions. That's not how our banking or credit unions work in this state, or anywhere for that matter. I would conclude with these remarks. The Court of Appeals decision is consistent with North Carolina law. It's consistent with the principle that arbitration is favored in this state, and it reflects really the realities of the situation in the modern economy. What Ms. Phillips is asking for here is to try to take this consumer form contract and turn it into some kind of a deal that she separately negotiated with the credit union, and that's not the record before this court. It's not the reality of the situation. And what she's arguing for would significantly undermine how credit unions engage with their members, change membership terms, and provide appropriate notices. So we would ask that the Court of Appeals opinion be affirmed. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I want to begin with illusoriness. My friend on the other side said, well, maybe it's illusory in some other ways, but it's not illusory as it's applied here. I would invite the court to look at all those federal appellate decisions that we cite in our brief, because that was essentially the argument, the losing argument made in all of those cases, because the way that the courts reasoned were that, well, you aren't actually bound to arbitration. You could still change your mind, and that's why the contract's illusory. It wasn't that the businesses had in fact changed their minds about arbitration that the contracts were held as illusory. The question about illusoriness is, what did you actually bind yourself to facially, just looking at the contract? It doesn't matter what actions one party takes after that. And going back to your question, Justice Behringer, I would invite the court to look at appendix page 42 of our reply brief. And on that page, you can see a good discussion from the restatement of consumer contracts, which my friend has invited the court repeatedly to look at. It's talking very clearly about retroactivity. And I'm just going to read a quote because I think it's quite helpful. When one party to a contract retains the unilateral right to amend the agreement governing the party's relationship, its exercise of that right is constrained by the covenant of good faith and fair dealing, which precludes amendments that operate retroactively to impair accrued rights. Of course, that's what we had here. We had an accrued breach of contract right. That's what this case is a breach of contract case that had already accrued when the arbitration rider was being added.
But the arbitration rider didn't prevent your client from pursuing that claim, did it? It just had to do with the forum where it would be pursued.
That's right. It didn't try to take the claim that right away, but it's retroactively taken. So they had already consented to jurisdiction in Mecklenburg County. Certainly took that right away for her to do that. And my friend says that the venue selection clause still applies in this case. We agree that the venue selection clause still applies. That's our point, that it's not actually been changed at all. It still applies if no party selects arbitration. It still applies in some of the carve-outs when arbitration doesn't apply. And it still applies even if there is an arbitration, because there has to be a court for where the arbitral award is going to be confirmed. And it applies just the same. That's why it wasn't changed, and that the arbitration rider is an addition and not a change. My friend says that Beatty is one of our key cases. I mean, I think it's cited maybe handful of times in our brief. I would not consider that to be one of our key cases. It has a lot of helpful thoughts, but I don't think that the best analysis is really there. I think the best analysis for this court to look at is the land decision that we discussed earlier, the Pruitt case of the Wisconsin Court of Appeals, which looked at our Court of Appeals opinion in this case, the Canteen case, expressly disagreed and explained its disagreement with the majority's reasoning and explained its agreement with the reasoning of the dissent. I also want to note, when it comes to their cases, if you actually take a look at them, most of them are about unconscionability. They actually aren't about any of the issues that we have raised in this case. They're not about illusoriness. They often don't involve retroactivity. Certainly the courts are not, the parties are not bringing the retroactivity problem to the court's awareness. So I would ask that the court sort of set those in one bucket. This is not an unconscionability case. We don't think that's the right way of looking at the issue. To turn to the Macasero case, it's another one of these cases that don't address the types of issues that we are arguing. Now, I understand that the credit union might have preferred to litigate against the litigant in that case, but our arguments are about the illusoriness of the unilateral modification clause. There's no discussion in the Macasero case about the enforceability of the unilateral modification clause. They didn't have an analysis of acceptance through silence. That's our other argument in this case. So there are many cases out there, and they are all of various levels of helpfulness. Many of them are about unconscionability. They don't talk to the issues in this case. Many of them, they were just litigated in quite a different way. Macasero also has the problem that it's relying on this decision called Coates, and Coates itself said, well, unilateral modifications are fine because there's legislation from our legislature that allows unilateral modifications. The General Assembly can enact that kind of legislation anytime it wants, but it hasn't been enacted in North Carolina. It's not clear, in most of those states, it only applies to credit card companies anyways, and certainly not to financial institutions like we have here. Ultimately, we see this case as being about illusoriness when it comes to the unilateral modification clause. And we understand, we don't see a good argument for why this contract is not illusory. All the other courts that have considered these types of issues have all agreed with us that it's illusory. And we think that there is no basis for saying that there's acceptance through silence in this case. We'd ask that this court reverse the Court of Appeals, affirm the trial court, and remand for further proceedings. Unless there are any other questions, give it back to the court.
Thank you. Thank you, counsel. Thank you.